In this second part of our seminar on human rights during emergency situations, we're going to look at whether the measures that England has introduced to combat COVID-19 are consistent with international human rights law, and whether the UK needs to derogate from the European Convention on Human Rights in order to implement them. Firstly, let's begin by looking at the measures that have been introduced. The primary measures introduced that we're going to look at today have been adopted through secondary legislation, namely a statutory instrument, SI 2020/350. These have been adopted under the Public Health Control of the Disease Act of 1984. Now, the measures cover a range of things, but I would like to break them down into three key elements. Firstly, the closure of some businesses and public buildings. Secondly, restrictions on assemblies over 2 people. And thirdly, restrictions on movement. Looking at the closure of businesses and public buildings, these measures introduced cover a range of things, such as the closure of businesses where food and drink are sold on the premises, the closure of places where goods are offered for sale or hire, holiday accommodation, and places of worship. Now, there are a number of exceptions to this, but it will clearly have impacts on a variety of different human rights. In particular, the right to peaceful enjoyment of possessions and properties under Article 1 of Protocol 1 to the European Convention on Human Rights, the right to freedom of assembly under Article 11 of the European Convention, and of freedom of thought, conscience, and religion under Article 9. The measures aimed at restrictions on assembly stipulate that no person may participate in a gathering in a public place of more than 2 people, subject to a number of exceptions. We will discuss these in more detail shortly. However, it's clear that these will have a significant impact on the right to freedom of assembly, the right to private and family life under Article 8 of the European Convention on Human Rights, and also the right to freedom of expression. Finally, the measures which have been categorized as restrictions on movement say that no person may leave the place where they are living without a reasonable excuse. This clearly impacts the right to freedom of movement under Article 2 of Protocol number 4 to the European Convention, but the UK has only signed this protocol and not ratified it, which means that it is not bound by it under international law. The measure could also impact on the right to liberty and security, opening the question of whether we have all been deprived of our liberty in our homes by the state and whether this is legal under international human rights law. We'll explore this shortly. In defense of the measures, overall, I would say that they include a range of relevant exceptions which show that there has been some thought given to proportionality. Many businesses are still allowed to remain open, even things like off-licenses, and this indicates that the closures are at least somewhat tailored directly to the risks emanating from human contact in enclosed spaces. The fact that people are allowed to leave their homes with reasonable excuse, and the list of reasonable excuses is non-exhaustive, means that there is scope to argue a variety of things are a reasonable excuse to leave your home. Again, this issue indicates some level of proportionality is being considered. Finally, the penalties for non-compliance with the law here are relatively light. There are no custodial sentences and only fixed monetary penalties applicable. The penalty imposed is a factor in evaluating whether measures adopted are proportionate or not. So the question then becomes, is there a legal need to derogate from the European Convention on Human Rights in order to implement these measures? Now, clearly, some states think that there is a need to derogate to implement these measures, like the ones that England has adopted in this instance. We have seen states like Armenia, Estonia, Georgia, Latvia, Moldova, Northern Macedonia, Albania, and Romania derogate from the European Convention on Human Rights in order to adopt so-called lockdown measures. The derogations adopted have varied from state to state. However, the common denominators that we see are derogations from the right to freedom of assembly and also from freedom of movement. It's noteworthy that Italy and France have declared states of emergencies, but not derogated from the European Convention on Human Rights. And while the UK has introduced emergency legislation, it has not derogated from the European Convention either. So, why is there so much disparity in the responses when each state is facing the same threat? Is there actually a legal need to derogate here? The content of the measures is not significantly different between different countries. If we take a look at Estonia, for example, it has issued the widest derogation from the European Convention on Human Rights, but the measures that it has taken are very similar to those that have been adopted by England. So, for example, Estonia has derogated from Article 5, the right to liberty and security, Article 6, the right to a fair trial, Article 8, the right to private and family life, Article 11, the right to assembly and association, Article 1 of Protocol 1, the right to property and possessions, Article 2 of Protocol 1, the right to education, and Article 2 of Protocol 4, the right to freedom of movement. Now, at the same time, the measures introduced have done things, as I say, that are very similar to what England has done. They have closed all schools and universities, switching them over to remote and home studying. They have banned all public gatherings. They have closed museums, theatres, and cinemas. They have closed social welfare institutions, hospitals, and detention facilities, and subjected them to a visiting ban. They have restricted movement to the islands. They have placed restrictions on leisure time. And they have also closed hotel and accommodation. They have reintroduced border controls and imposed a 14-day quarantine for everyone entering the country. It's notable that the UK has not introduced this final measure. So, Estonia has considered it necessary to derogate in order to implement each of these particular measures. However, while this is possibly required under human rights law, we should also note that there is a great deal of flexibility in international human rights law as it stands to respond to these issues. So let's examine whether they could be consistent with human rights law without a derogation. In England, the law has been changed so that no person may participate in a gathering in a public space of more than 2 people, except members of the same household, gathering for essential work purposes or to attend a funeral, or where reasonably necessary to facilitate a house move, provide care or assistance to a vulnerable person, provide emergency assistance, or participate in legal proceedings. These are just some of the examples of exceptions in the law. The question is, can this be consistent with the right to freedom of assembly and association? Well, it's notable that states are allowed to interfere with the right to freedom of assembly, provided that a number of conditions are met. Firstly, that the interference is prescribed by law. In this case, it is clearly prescribed by law in the Health Protection Coronavirus Restriction England Regulations of 2020, those mentioned at the beginning of this seminar as in the statutory instrument. The second question is whether it pursues a legitimate aim. Clearly, this does pursue a legitimate aim in that it is attempting to spread the coronavirus in the UK and to protect the health of citizens. The third issue is whether it is proportionate. So the questions here are whether the measure was capable of achieving the aim it was attempting to achieve, whether there were less intrusive measures available to achieve the aim, and whether a fair balance was struck between the interests of the community and the individual. Now, typically, states normally run into issues in respect of the proportionality test at the European Court of Human Rights. Now, in this respect, while the measures on assembly are clearly harsh, it's debatable whether there is any other way to stop the spread of the disease at present. Science seems to indicate that it is transmitted by close human contact. There are no vaccines available, and therefore restricting contact is viewed as the only viable measure of disease control available at this time. In the past, the European Court of Human Rights has also accepted the dispersal of protesters to protect their health and safety. In Cisse versus France, for example, when a group occupied a church in France and went on hunger strike, it was not considered a violation of the right to freedom of assembly to disperse them, as it had been done to protect their health and safety of these protesters. We should also note that the European Court of Human Rights gives states a margin of appreciation when it is approaching issues like this. The margin of appreciation is applied in two distinct ways. Firstly, to mediate the relationship between individual rights and collective goals under the European Convention on Human Rights, and secondly, to address the limits or intensity of the review of the European Court of Human Rights because of its status as an international court. Now, in the first instance, when we see the margin of appreciation being used, the idea is that states are justified in taking legal measures to advance collective goals, in this instance, the protection of human health. The court examines whether a fair balance is struck between the collective goal, in this instance disease prevention, and the individual interest, in this instance the freedom to move around. And when the court refers to the margin of appreciation in this context, it is merely expressing a conclusion not to intervene after it has applied a thorough analysis of necessity and proportionality. In other cases, the court uses the margin of appreciation to mitigate the effects of international review. In this sense, the margin of appreciation is used to mediate the relationship between the court and the state. It enables the balancing of the sovereignty of the state with their obligations in the Convention. This is based on the principle of subsidiarity, the idea that the national judge is better placed in certain circumstances to judge a situation than an international court's judges. The combined effect of each of these approaches is that states are given much more leeway to respond to things as they see fit, especially in emergency situations. The European Court of Human Rights will very likely give states the benefit of the doubt here. It's also worth bearing in mind that states owe a positive obligation to their citizens in this context, an obligation to protect them against the spread of this disease. It clearly meets the criteria for the invocation of the positive obligation under the right to life. This arises where authorities knew or ought to have known of a real risk to the lives of people within its jurisdiction and failed to take adequate measures to protect them. And this obligation can apply to any activity, whether public or not, in which the right to life may be at stake. I would suggest that in light of the current crisis and the uncertainty that it has given rise to, not just in terms of science, but also in terms of how best to manage the situation, the European Court of Human Rights is likely to give states a lot of discretion and leeway in how they handle it, including whether they decide to derogate from the Convention or not. However, this is where the issue of testing comes to the fore, and also the need to keep the measures under review. Thus, if we could be sure that a person did not have the virus and was mixing with others who also did not have the virus by testing them, there would be no need to restrict assemblies in such an indiscriminate way. The longer the measures are in place, the lack of testing goes on, the less proportionate these measures become. So overall, the interference with the right to freedom of association is probably acceptable for the time being. A question I'm sure many have contemplated over the past weeks is whether the government has deprived you of your liberty. So let's look at what the law says and then how human rights law applies to it. So when we look at the specific measures adopted, they say that no person may leave the place where they are living without reasonable excuse. This includes a non-exhaustive list of reasonable excuses. Illustrative examples include the need to obtain basic necessities, including food, medical supplies, including for pets and animals, to obtain supplies for the essential upkeep, maintenance, and functioning of the household, to take exercise, either alone or with other members of their household. It's worth noting, in respect of the provision on exercise, that no time limit is actually stipulated. The time limit is government policy, not law. It also specifies that you can leave to seek medical assistance, to provide care or assistance to a vulnerable person, to donate blood, to travel for the purposes of work, including voluntary work, where it is not reasonably possible for the person to work or provide those services from the place where they are living. Another reasonable excuse is considered attendance at a funeral or to fulfill a legal obligation, to access critical services, including childcare and educational facilities, to continue existing arrangements for access to parents and children, for religious leaders to go to a place of worship, or to move house where reasonably necessary. Finally, it should be noted that when it says people may not leave the place where they are living, this includes gardens, so you should be allowed to stay in your garden. You don't have to stay inside your house. Now, it's worth noting that even the majority of states that have derogated have not derogated from the right to liberty and security. The only states that have derogated from the right to liberty and security are Georgia, Estonia, and Armenia at this time. It seems instead as though many states are considering the measures they are imposing as a restriction on movement rather than a deprivation of liberty. So the question then becomes, what is the difference between a deprivation of liberty and a restriction on movement? Historically, we have seen very significant restrictions on movement, including house arrest, not deemed to amount to deprivations of liberty under the European Convention on Human Rights. The European Court of Human Rights stated in the case of Guzzardi versus Italy that account must be taken of the whole range of criteria, such as the type, duration, effects and manner of implementation of the measure in question. The difference between deprivation of and restriction upon liberty is nonetheless merely one of degree and intensity and not one of nature and substance. This is, as Harris, O'Boyle and Warbrick and others point out, a very lenient definition of what constitutes a deprivation of liberty. We can see this in cases that followed involving curfews, with the court accepting that a curfew of 10 hours did not amount to a deprivation of liberty for the purposes of Article 5 in Raimondo versus Italy, and accepting a longer curfew in the case of Trijonis versus Lithuania of 12 hours. In the UK specifically, even wider restrictions on movement have been endorsed as not amounting to deprivations of liberty. Going back to the case of A and others versus the UK, when the detention measures there were considered unlawful, the UK adopted control orders instead, introducing a range of measures to limit suspected terrorists' movements and freedoms. These included curfews of over 20 hours a day. Now, the House of Lords in the UK, what is now the Supreme Court, held that a curfew of up to 18 hours a day did amount to a deprivation of liberty for the purposes of the European Convention. But the Supreme Court later accepted that a curfew of 16 hours would need to have other conditions along with it that were unusually destructive of the life the controllee might otherwise have been living for them to amount to a deprivation of liberty under Article 5. So to summarise, in the UK at least, not allowing somebody to leave their house for up to 16 hours a day did not amount to a deprivation of liberty. But it's important, as the court noted above, to look at the surrounding circumstances as well when determining this. We have other precedents here coming from freedom of assembly law that we should also consider. In the case of Austin and Saxby versus the United Kingdom, a large group of protesters had assembled in the centre of London to protest during International Workers' Day. The police were not notified that the demonstration was going to take place by the organisers, as required under domestic law, specifically the Public Order Act of 1986, and the organisers were not cooperating with the police, and a number of protesters were becoming violent and disorderly. In response, the police established a cordon around the protesters for a number of hours, sometimes referred to as a kettle, or the process of kettling. This enclosed thousands of protesters inside it. Now, the people were kept in a cordon for many hours and were only allowed to leave if the police gave them specific permission. A number of other people who were passing through the area at the time were caught in the cordon, and some of these brought a complaint to the European Court of Human Rights, alleging that the police had deprived them of their liberty. Now, in the domestic courts, even though there was no specific exemption under Article 5 for deprivations for the maintenance of public order, the House of Lords dismissed the case, ruling that this case fell outside the scope of Article 5 and did not amount to a deprivation of liberty. They held that measures like this would not amount to deprivation of liberty as long as they were not arbitrary, were resorted to in good faith, and were proportionate and enforced for no longer than was reasonably necessary. Now, these conditions were apparently met in Austin because the cordon was imposed purely for crowd control purposes, imposed to protect people and property, was used to stop people bent on violence and impeding the police, that the purpose and reason for imposing the cordon was clear to those constrained within it. It lasted for as short a time as possible, and that those who were not demonstrators or were sufficiently affected by being confined were promptly permitted to leave. Now, when this case came before the European Court of Human Rights, they stated that Article 5 must not be interpreted to make it impractical for the police to maintain order and to protect the public, as long as the techniques used protected the individuals from arbitrariness. The court, in this instance, had to take into account the type, duration, effects, and manner of implementation of the measures in question. Now, when the court looks at this, it drew a distinction between deprivation of liberty and restriction of liberty, stating that the difference, as mentioned in the Guzzardi case, was one of degree and intensity. In this case, the court thought that the police had no alternative but to impose an absolute cordon to avert a real risk of serious injury or damage, and that this was the least intrusive, most effective means to be used. As a result, it did not amount to a deprivation of liberty in the circumstances. So what can we conclude about the coronavirus restrictions and these precedents established by the European Court of Human Rights? Well, in the first instance, it's worth pointing out that the distinction between deprivation of liberty and restriction of movement is not clear in the case law. The European Court of Human Rights approach in Austin, in particular, has been criticised, not least by a number of dissenting judges in the case itself. It is difficult to rationalise how keeping someone in a cordon against their will for several hours is any different to the police locking someone in a cell for a few hours and then releasing them. The person detained in the cell is clearly considered to be deprived of their liberty. The person in the cordon, following Austin, for some reason, is not considered to be deprived of their liberty. Looking directly at the coronavirus regulations themselves, the degree of coercion in the enforcement of the coronavirus restrictions and penalties for non-compliance are quite limited. If you leave your home without a reasonable excuse, the police have the power to take you back and or issue you with a relatively small fine of £60. They cannot arrest and imprison you directly under the legislation, but the police can use reasonable force to implement these measures, meaning they could physically force you to go home if necessary. Now, the intensity of the restriction is also worth examining. The regulations allow you to leave your home, but you need a reasonable excuse. This would distinguish them from other deprivations of liberty where you can't leave, such as when you are imprisoned, and even curfews, where you can't leave for any reason within a specific time period. On the other hand, the coronavirus regulations will potentially be imposed for a much longer time than the cordon in Austin, and even the control orders in the UK cases, such as JJ. It's also worth noting that this is a blanket policy. In cases where control orders were imposed, this was following a legally established process directed at specific individuals for their personal behaviour. In this case, the case of coronavirus regulations, the measures are imposed on everyone, so they have a much broader scope and are completely indiscriminate, impacting on the proportionality of the measures. Having said that, in the case of Austin, the European Court of Human Rights did not seem particularly concerned that innocent parties, non-violent protesters and bystanders were also caught in the police cordon, where there was no alternative for this to happen. They could apply a similar logic to the restrictions on movement in the UK regulations, though it should be noted again that the cordon was in place for a much shorter period of time. Ultimately, we can probably conclude that at this point in time, the coronavirus regulations are probably a restriction on movement, but they could very easily transform into deprivations of liberty with the passage of time. The fact that these may be imposed in an indiscriminate fashion over a long period of time will be the issue, especially in the absence of widespread testing for the virus. We can envisage claims, for example, asking why a person was locked in their house for weeks when they could have tested people and quarantined the ones that were actually posing a risk. Yet even if the measures have transformed into a deprivation of liberty, there is scope in the right to liberty and security to introduce such measures. Article 5 of the European Convention states that everyone has the right to liberty and security of the person, and that no one shall be deprived of his liberty save in the following circumstances and in accordance with the procedure prescribed by law. And one of the specific circumstances in which people can be deprived of their liberty is the detention of persons for the prevention of the spreading of infectious diseases. So as human rights law permits the detention of people for the prevention of the spreading of infectious diseases, there would be no need in principle, at least, to derogate from Article 5 in order to implement these measures. So there is no legal need for the UK to derogate in order to implement these measures. But the question then becomes, is there a case for derogating even if it is not legally necessary because it is desirable? A number of academics have taken different views on this. Getchiaru has taken the view that derogations send an unnecessary message to people that states will start limiting their human rights. My response to such a view is that states have already limited people's human rights, and the significance of a derogation is that it would emphasize that this limitation on rights is the result of an emergency situation, that it is temporary, and will be subjected to appropriate scrutiny. This isn't just about what is legally necessary or not. This is also about drawing a clear distinction between normality and emergency. If we fail to draw such distinctions, we invite challenges to human rights protection. If we look at the control orders case, for example, these imposed a variety of restrictions on individuals, including placing them under house arrest, limitations on their movement, electronic tagging, and forced relocation. The UK never derogated to implement these measures, and this exerted pressure on the normal protection offered by several rights, particularly liberty and security and the right to a fair trial. It forced courts into difficult choices over whether to uphold these measures deemed necessary to prevent terrorism, and ultimately led, as Fenwick and Phillipson argue, to minimal interpretations of certain convention rights that strip them of much of their content. So by allowing these exceptional measures to exist in our normal legal frameworks, we invite the weakening of human rights protections. The emergency measures poison human rights protections in times of normality and compromise the levels of protection normally given by the Convention. You can take a different approach. You can clearly separate these laws, isolating the emergency measures by derogating. This means that when courts come to interpret the laws, the normal right is shielded. If the right to liberty and security is subject to a derogation, the court's interpretation of the right to liberty and security is not impacted by the court's decisions, which are limited to the specific, unique circumstance of the emergency situation. In principle, we should also note that a derogation would facilitate proper scrutiny of the measures adopted, including their compatibility with international law and whether they are required by the exigencies of the situation and the adequacy of domestic scrutiny measures.